Sir, you can come on up to the podium. We're ready. If you are. Or-
Good morning.
Good morning.
I'm Webb Brewer from the Shelby County Bar, and I would like to reserve 5 minutes. If
5 minutes?
Yes.
All right, sir. You may proceed.
Okay. This is an appeal from the Chancery Court of Shelby County, Tennessee, which granted a motion for summary judgment to the defendant. This is a case for fraud in the inducement, rescission based on fraud in the inducement of a mortgage loan transaction. And the plaintiff sought rescission along with damages for several other claims. Most of the damage claims were dismissed by the federal district court. The case was removed early on to district court and then later remanded back. Briefly, it's been the contention of the petitioners, the James, or Mr. James, that this is a predatory loan transaction that consisted of 2 mortgage loans, a first and second, with some pretty egregious terms, loan terms. The first mortgage was an adjustable rate mortgage that started out at 7.4%, but could go up to as much as 14.4%. And in fact, in the truth in lending disclosure, was going to go up by 2 points on the first change date, which was in 2 years, and then it changed every 6 months thereafter. The plaintiffs could afford the original loan terms. The second was an interest-only balloon payment, which is a 20% of the loan value. But they could not, once the changes started, they could not make payments. They had employed a mortgage broker, a company called Liberty Lending, and a licensed broker named Reginald Perham. Mr. Perham, or Mr. James, believed that Mr. Perham was acting in his best interest. He had gotten a mortgage broker because this was a time in around 2005 when the lending industry was kind of crazy, and he thought that he needed professional guidance. As it turns out, it came to light that in discovery that Mr. Perham had been paid a yield spread premium by the original lender, which was First LLC Financial. That was not understood at all by Mr. James, and he testified that if he knew of that his agent was being paid by the opposing party, and also Mr. Perham testified that the yield spread premium was based on how much more profitable the loan was to the lender than what the borrower would have qualified for. And our position all along has been that this is just a basic contradiction. If the broker is working to get the best possible deal for his client and at the same time accepting compensation from a mortgage company to get more profitable terms for them and less profitable or less good terms for the borrower, and especially when that's not understood. Now, Mr. Perham was very candid in his testimony about just how toxic some of these loan terms were, and in fact testified that the adjustable rate mortgage and the way of changing and the the interest-only second with the big balloon payment were both likely to cause the loan to end in foreclosure. That engendered this lawsuit, and again, we were seeking fraud in the inducement or rescission and restitution based on fraud in the inducement. Now, the trial court found that the trial judge basically discredited all of Mr. Perham's testimony and said that it was not credible, although from our perspective, he made a number of admissions that were against his own interest. We had moved for a bifurcation of liability and relief because we were seeking restitution or rescission and recognized that we would have to make restitution. That was never ruled upon by the court, and the trial judge found also that Mr. James could not make restitution of the face value of the first mortgage loan, which was $136,000. We had argued that we don't know that the loan was transferred a number of times, and we had argued that we don't know, and there was no way to know if restitution is to put the parties back into the position that they were in, that you would have to know what this party that was party to the lawsuit had paid to make the appropriate amount of restitution. So those were our basic arguments. The defendants have relied a lot on saying that Mr. Perham was not the agent of the lender, the original lender, and they're relying on this Nave case, which was an appeal from the bankruptcy court in the middle section that was at the district court heard that appeal. That case, we think, ignores a series of cases from the Tennessee Supreme Court. The Givens case, White v. Revco, and I'm forgetting the name of the third right now, but there were three, starting in 2000, there were three decisions from the Tennessee Supreme Court in which the court found that it made a number of exceptions to the traditional agency versus independent contractor dichotomy.
So what factors do you say made this gentleman an agent of the lender?
Well, first of all, that series of cases that I've cited in my brief says that even if one is not an agent in the traditional sense of the word, there still can be vicarious liability if the principal directed or commanded or knowingly accepted the actions of the agent. And we submit that that's precisely what happened here. The original lender had participated in getting mortgage brokers like Mr. Perham to try to steer their clients into higher cost loans than what they would have qualified for based upon compensation. So looking at that line of cases from the Tennessee Supreme Court, we think that it was clear that first of all, that the principal, First NLC Financial, was guilty of wrongdoing themselves, and they were incentivizing the mortgage brokers to act in a way that was more profitable and to their benefit. So based on that line of cases, whether you say that, I think that it's fair statement to say that after the White and the other cases that I've cited, the law in Tennessee is that the examination doesn't stop at a question of whether this person is an independent contractor or an agent, but you have to look at the totality of the circumstances and whether the principal directed the conduct, and certainly that was what had happened here, we would say. So I think it's kind of semantical whether you say he was an agent or not, but I think that's a fair statement of the state of the law right now.
All right, you've used your initial time.
Okay, thank you.
Thank you. You still got your rebuttal.
Good morning, Your Honors. May it please the Court. My name is Brett Chanis, and I'm joined by my colleague, Amanda Beckett, and we represent the appellees, Petra Finance and Clear Spring Loan Services. We respectfully ask that you affirm the trial court's judgment. 20 years ago, Your Honors, that is when the appellant obtained a loan from First LLC that he claims he should be able to rescind because the loan broker that he hired to help him obtain a loan was paid what he claims is a fully disclosed fee from the lender for helping them to originate a loan with a higher interest rate, and that this somehow qualifies as fraudulent inducement. The appellant waited just shy of 10 years to file his lawsuit, only unhappy with his loan, which he even modified in 2007 once he became unable to repay it and was facing imminent foreclosure. The lawsuit was filed against Clear Spring, the loan servicer, and Petra, the assignee of the loan, who the appellant admits is a holder in due course of the promissory note. The trial court granted the appellee's motion for summary judgment on the basis that there was no evidence that the loan broker was an agent of the lender, and because the appellant admitted that he could not restore the status quo if the loan was rescinded.
Let me ask you a question that is very problematic for me. Looking at the final order of the trial court granting summary judgment, looking at specifically page 2, the last sentence in the first full paragraph, the trial court's discussing Mr. Parham, I believe, P-A-R-H-A-M. The last sentence of that paragraph says, the court deems his testimony to be self-serving and have no credibility. Don't try to answer my question before I ask it. This is summary judgment. Can the trial court do that?
Your Honor, I fully agree that that statement is wrong. A trial court cannot weigh credibility on summary judgment. I'm in full agreement with you on that point, but I don't believe that that is conclusive to this appeal because even...
Well, let me ask you a second question. Apparently, according to Mr. Brewer, Mr. Parham is the agent and testified about a lot of things. If the trial court makes that statement and totally discounts everything Mr. Parham says, and does it because of credibility, don't we have a problem with summary judgment here?
Your Honor,
as far as Mr. Parham's concerned, if that's his name.
Your Honor, I'm in full agreement that the trial court should not have discounted his testimony, although even considering his testimony and the admissions of the appellant, the trial court is rightfully granted summary judgment, and this court can affirm for any reason supported by the record, even if it was not relied upon by the trial court. And here, the appellant below, in his arguments, focused solely on the fact that arguing Mr. Perham was an agent of the lender, something he now completely disavows. If you look at the appellant's brief, his argument is focused on Mr. Perham. Well, he was an independent contractor, but there is this line of cases, Givens, notably the one that he's focusing on, which says that a principal can be vicariously liable even for the acts of an independent contractor. However, that argument was never made below. If you look at volume 7 of the record, pages 1039 through 1042, the argument is solely focused on Mr. James trying to convince the trial court that Mr. Perham was an agent of First NLC. However, he has completely changed his theory before this court, essentially admitting that Mr. Perham is an independent contractor, stating in his brief that, quote, First NLC did not apparently control the time or manner in which Mr. Perham did his work for it. Control is the #1 factor in looking at whether an entity or a person is an agent or an independent contractor. So we think that there is a problem here, a waiver problem, with the appellant trying to argue a completely different theory that he did not present to the trial court. But even looking at his arguments that he made in his brief, Your Honor, and before this court, in Givens versus Mulliken, which is the case that he's relying upon, the court in that case said, the Tennessee Supreme Court said that, quote, a principal can be held liable for the harm caused by the directed or knowingly authorized acts of an agent, even if that agent would otherwise be considered an independent contractor in the absence of any such direction or authorization. The court seemed to be careful in calling that person an agent. And in Givens, the court was looking at whether an attorney hired by an insurer to represent an insured could be considered an agent of the insurer rather than an independent contractor. And the Supreme Court there found that the attorney, or that the insurer could be liable for the acts of the attorney because, quote, although an insurer clearly lacks the right to control an attorney retained to defend an insured, we cannot ignore the practical reality that the insurer may seek to exercise actual control over its retained attorneys. So the Supreme Court was really focused on what type of actual control was exercised over that attorney by the insurer, who would otherwise have been an independent contractor but for the control. And as I stated in the appellant's brief at page 37, he admits First NLC did not apparently control the time or manner in which Mr. Perham did his work for it. So from that standpoint, we think that's the end of the story right there, that he admits there is no control from First NLC over Mr. Perham. So even if this Givens case could be of any help to him, or if it could apply, it simply doesn't work for him because of the complete lack of control. So the trial court did correctly grant summary judgment on that basis. And the other basis on which the trial court granted summary judgment was that Mr. James admitted that he could not restore the status quo if the loan was rescinded. That is a prerequisite to rescission. Counter to Mr. Brewer's argument that the trial court should have bifurcated liability from restitution, that simply cannot be done because, as this court said in cases such as Layman versus Chamberlain in 1993, if the parties cannot be put in the status quo, or if due to the passage of time or other reasons equity cannot be done, there is no ground for rescission. So you have to figure out if somebody can restore the status quo before you could even figure out if there can be rescission. So you can't do rescission prior to determining restitution, because that would be just a complete waste of time if you go through that whole process and figure out they can't restore the status quo. Now, the appellant here freely admitted in request for admissions that he does not have the ability to restore the status quo. And his only argument as to why that should not have been a basis for granting summary judgment is because he says, well, what if Petra only paid pennies on the dollar for the loan from First NLC? Then my client should only have to pay pennies on the dollar for restitution. But that is not the law anywhere, and the appellant did not cite any cases in his brief for why that should be the case. Essentially, he's seeking a windfall here that he should only have to pay pennies on the dollar for restitution. But in cases such as Yarlett versus Yarlett, this court has held this court has repeatedly held that a party's failure to cite any authority for its argument leads to a waiver of that issue on appeal. And because there is no case law presented to support that position whatsoever, we believe that the trial court's judgment on that basis should be affirmed. And as I mentioned, there are two additional bases upon which the trial court's judgment should be affirmed, namely the statute of limitations. As I mentioned, this case—
Trial court rule on those?
Your Honor, the trial court did not. That argument was clearly raised. That was the first argument in the appellee's motion for summary judgment about the statute of limitations. But this court can affirm for any reason supported by the record.
Court normally doesn't deal with issues that the trial court didn't deal with on summary judgment issues.
Well, this, to be fair, Your Honor,
I'm not telling you you can't make your argument, but I'm telling you you're probably not going to get a lot of traction.
Okay. Well, I appreciate that, Your Honor. As I said, it was an argument that was clearly raised in our motion for summary judgment, and we argued below that that this summary judgment should have been granted because fraudulent inducement claims have a 3-year statute of limitations under Code Section 28.3105. And this statute bars claims after 3 years for, quote, actions for injuries to personal or real property, end quote. In 1977, in Vance versus Shoulder, the Supreme Court was dealing with a plaintiff that had alleged fraud in the inducement of a contract. And in that case, the court noted that a plaintiff in such a case can either sue for damages under the contract or rescind the contract in equity. And the plaintiff in Vance was suing for damages, and the court held that fraud in the inducement claim is subject to a 3-year statute of limitations under 28.3105 for actions to injuries to personal or real property. And 4 years later, in Prescott versus Adams, this court was asked to look at the statute of limitations for fraud in the inducement. This time it was a case where a plaintiff had alleged fraud in the inducement of a purchase agreement where a seller had allegedly misled the buyers about prior mudslides, and the buyers, after closing, had a significant mudslide in their backyard. There, the plaintiff sought to rescind the contract rather than seek damages. But this court in Prescott said that equity follows the law, and, quote, the right to relief in equity becomes barred when a right of action at law for damages is barred, end quote. And that has long been the law in Tennessee. The Court of Errors and Appeals back in 1812 in Shelby's Errors versus Shelby, 3 Tennessee 179, found that the statute of limitations on a cause of action is the same regardless of if the relief sought is at law for damages or equitable. In that case, the court said, quote, it is the nature of the cause of action that must determine the application of the statute and not the nature of the relief which can be afforded. And based on this principle, this court in Prescott held that the 3-year statute applied to claims for fraud, for rescission, for fraud in the inducement. And I would be remiss if I didn't point out that in 2014, the Sixth Circuit in Humphreys versus Bank of America rejected the 3-year statute of limitations to a fraudulent inducement claim where the plaintiff, such as Mr. James, claimed that they were fraudulently induced to obtain a mortgage loan. But we contend that the Sixth Circuit misapplied the law in Humphreys, and this court obviously is not bound by that decision. The Sixth Circuit looked at Prescott, which we just discussed, the mudslide case, and found that, noted that that case concerned actual physical damages to real property, and therefore the Sixth Circuit said that brought the case within the real property injury provision to 28.3105, and the court seemed to believe that, quote, the financial loss of accepting an unfair loan, end quote, which is what the court said they were dealing with, was not within the reach of that statute. But, Your Honors, if you look at the Vance decision from the Supreme Court in 1977, that court said a financial loss, or what they called a loss in value sustained by the plaintiff, caused by, quote, the alleged tort of fraud and deceit is included within the phrase injury to personal property, end quote. So it appears that the Sixth Circuit in Humphreys relied far too much on the real property injury provision and ignored the personal property injury provision to 28.3105, which Vance says covers financial loss caused by the tort of fraud and deceit. And here, the appellants claim that they were damaged by having to pay more interest than they should have due to this yield spread premium, just like the plaintiff in Humphreys claimed he had to pay more. And since financial loss under Vance is a personal injury, the 3-year statute of limitation should have applied, and this case should have been brought no later than 2008, 3 years after the loan was originated. And lastly, Your Honors, it is an undisputed fact that Petra is a holder in due course of the promissory note, which was an admitted fact by the appellant. And under the UCC, specifically 47.305 subsection 2, a holder in due course obtains a promissory note free of the fraud and the inducement defense that is only available against the originating party. So that is another basis to grant summary judgment. So in sum, Your Honors, we believe that the trial court correctly granted summary judgment, but there were additional bases upon which this court could affirm. The appellant should not be allowed to wait 10 years and then drag a case on for another 10 years without paying their mortgage in order to rescind a loan based on an issue that they claim was fully apparent at closing. Thank you, Your Honors.
Thank you. Mr. Brewer?
Just a few points that I'll make briefly. First, Mr. Chan has argued that the yield spread premium was disclosed on the closing documents. He argued pretty extensively in the his brief, that it could not possibly be unknown or undisclosed. There was a line in the closing statement, the HUD-1, that said yield spread premium and $2,000 and a little over $2,000. That was not explained by the closing attorney according to Mr. James' testimony. And yield spread premium has no meaning to most people. I think that that term was used precisely for that reason. It's kind of an amorphous sounding term, so I don't think that there was an effective disclosure at all.
Couldn't Mr. James have asked questions about that or even refused to follow through with the purchase and the loan if he didn't get satisfactory information on it?
No, I don't think so. I mean, I think it went in closings, and I'm sure you're well aware there are a lot of documents and a lot of fairly technical things.
Well, there are a lot of documents and a lot of technical things, but as an attorney in practice, I had a lot of experience in closings, and people ask questions, and I've even seen closings not occur because people ask questions about numbers that they didn't understand and didn't know was going to be on their settlement statement. And so no one forced him to sign this, did they?
No one forced him to know, but I do think two things. The way that that was disclosed in the document, it was, he just didn't catch it, and I think it's pretty understandable that it would not have been caught. And had he could have said, what is this yield spread premium? I don't know anything about that. He didn't. And I would say that was one of the reasons that he hired a mortgage broker, because he felt like he needed assistance. He wasn't a sophisticated person in these matters, and he thought he had someone who was acting on his behalf, and it turned out that that trust was misplaced. But I don't think that it's pretty obscure if you look at the document, and again, I think that he believed that Mr. Perham was acting in his best interest in getting the best agreement that he could get, and he just didn't know it and didn't question it. The other thing I wanted to mention, Mr. Chanis had talked about a couple of things that he covered in his brief fairly extensively. One was the statute of limitations issue. The Humphreys case, which was decided by the Sixth Circuit Court of Appeals, I happen to represent the petitioner in that case, but it clearly held that either the 6-year statute or a 10-year catch-all statute was the applicable one. Subsequent case, the Partee case, the district court held that, it made a distinction between damages to property. The damage here was not to property, it was in the loan that financed the transfer of the property. I think that section more clear is fairly clearly one about like damage to, the foundation of a property because of a water leak or something, rather than in the financing. So we would argue that the 10-year statute, the catch-all statute, was the appropriate one. And I'm out of time, so I'll stop there.
Thank you. Thank you, counsel. We will review the record, take this matter under advisement, and attempt to get you an opinion at the earliest time. Thank you. You may be excused. You all right?